All right, welcome everyone. We're going to get started here. Going to introduce our speakers, take you all through a high-level outline of what we're going to talk about, and then we'll dig in. So without further ado, we have two of our attorneys from the LA office and myself from DC. David Fink is an experienced media and entertainment litigator at both the trial and appellate court levels. His experience in the media and entertainment industry includes defamation and privacy claims, right of likeness, copyright, trademark, guild-related issues, and profits participation. David also regularly represents clients in general commercial disputes and on legal issues related to augmented and virtual reality. In this capacity, he advises clients on liability issues, venues, compliance rights, intellectual property concerns, and privacy protection. Sarah Cronin is an experienced insurance recovery attorney who represents policyholders, including media and entertainment companies, in both pre-litigation dispute resolution and litigation of breach of contract and bad faith actions against insurers. Sarah has worked extensively on securing coverage for claims such as copyright, trademark, defamation, invasion of privacy, and right of publicity, as well as expense coverage and coverage for bodily injury and property damage claims arising from insured productions. I'm an associate in Venable's insurance recovery and environmental groups. Among other things, I'm experienced working with clients to answer scope of coverage questions under a variety of policy types and working with insurers to ensure that clients promptly receive agreed to indemnification. Since COVID began, I've advised many clients on their event cancellation policies and have developed a niche expertise marshaling claims under those policies. Next slide, please. All right, back to the agenda. Our agenda for the day, we're going to run through some types of insurance policies that listeners in the media and entertainment industry should be aware of. We're going to talk about some cross-cutting issues, such as selection of defense counsel, negotiating rates, settlement and allocation, and given the events of the last year, we are also going to spend some time discussing COVID. Next slide, please. All right, so guys, as much as possible through the Zoom format, we really want this to be a conversation. We're not going to wait until the very end to answer questions. We're going to take them as they come, and we're also going to have a bit of a conversation between us speakers. So with that, please feel free to ask questions whenever you want, and I will turn it over to Sarah.
Hello, everyone. Let's see. Okay, so how we're going to start is we're going to talk about when a claim first comes in and what type of insurance policy should you be looking at for coverage. In terms of a claim, I'm going to skip ahead just a second. I think even just the concept of what actually constitutes a claim under an insurance policy can be an issue. The thing to know about that is claim is defined differently under each insurance policy that you have. So the kind of typical starting items that would constitute a claim can include obviously a lawsuit. There you're going to not be that surprised that could constitute a claim, but also a cease and desist letter you get from a plaintiff's counsel. And depending how claim is defined in your particular policy, it could even be a letter that doesn't actually ask for monetary relief. Maybe it was just injunctive relief, like, hey, you know, that movie can't go forward because X, Y, and Z. Request for tolling a statute of limitations can constitute a claim under some policies, and being served with a subpoena can as well. So the takeaway there for what constitutes a claim to kick all of this off is defined under each individual policy. Typically, the first line of defense when you get a claim in is going to be a media liability policy. These go by a lot of different names, and each kind of insurer has their own, you know, trademarked what brand name for their policy. But what it is it's essentially an errors and omissions policy that covers the types of claims you often see brought against media and entertainment companies. And those kind of typical claims are often copyright infringement, trademark infringement, defamation, invasion of privacy, right of publicity, idea submission claims. Those are typically the types of claims that'll be enumerated in the media liability policy as being covered claims. These are claims that are going to be brought by third parties. So a plaintiff, either sending that letter or lawsuit that we just spoke about, and they're usually going to have two separate components. There's going to be a duty to defend component, which will get triggered if there's any claim brought against you that could even potentially be covered, and we'll go into that a little bit more later in this hour. There's also a duty to indemnify that the insurer owes, which is going to be triggered by claims that are actually covered and farther down in the litigation. So farther down in that timeline of when the duty to indemnify is typically triggered. But what you're most concerned about in the beginning is the duty to defend and get the attorney's fees that you will inevitably be incurring pretty quickly covered by your insurance. The kind of thing you'll always hear in insurance presentations, but it's very true and it's worth mentioning again, is as soon as you get a claim, which could be that demand letter, is to let your insurance company know right away. There's a few different reasons for this. The first is certain policies have language in it that may make it a condition precedent to coverage of when you need to notify the insurance company. Certain policies require it to be made during the policy period, and there can be other provisions in there that are more specific. But the first reason is you don't want to be in a situation where you wait and then you have the insurance company arguing that there's late notice and therefore there's no coverage at all. And the second reason why you really want to do it is oftentimes, you get a claim for your company. Your first thought is probably not what kind of insurance I have, but I would like that thought to be the first. But really your first thought is probably getting on the phone with your trusted attorney that you typically use to handle outside counsel to handle these types of claims and to get them started, addressing how serious is this claim, what are our next steps, what are our deadlines. And as soon as you notify the insurance company, those defense costs can all be covered and you can later recoup those. But if you wait, those defense costs are considered what's referred to as pre-tender costs, and your insurance company is going to push back. And the general rule, though there are exceptions, is that the pre-tender, the pre-notification of your insurer of the claim, those costs would not be covered. So you want to make sure right away that you are teeing your claim up to get the most coverage under your policy. Tendering a claim or notifying the insurer of your claim is very simple, straightforward. We do it all the time, but clients also handle it all the time themselves. It's a very, we put 1 to 3 sentence email, or if they don't provide you with an email address and the policy to submit a claim, you can send a letter. And you're just keeping it very general. Just, saying, hey, we received X letter, please see attached. We're tendering and we're notifying you for defense and indemnity coverage. It can be quite simple. I wanted to bring up, so one of the things to consider when you get a claim in is that you're probably going to have a series of different policies. And all of these policies ideally work together, but part of that is that these policies are also meant to exclude certain things under one policy and cover them under another policy. So for example, if you have a media liability policy covering your production, you may think, great, we have insurance, we're fine. One typical exclusion though, in a media liability policy is an exclusion for bodily injury and property damage claims, which means that you're going to want to make sure you have that coverage either added to your media liability policy through an endorsement and paying an additional premium, or that you have it through another policy that would apply to the production. And it's good just to kind of, obviously the ideal is that all these issues are being thought out before the policy is placed or referred to sometimes as bound. We had a funny clip, but we could not show it, but I'll just describe it generally because this is, some of you out there produce reality television shows, and, so you have a television production going on. You may not be thinking right away bodily injury or property damage claims, but you could have a situation where cast members either get in a fight with themselves or get in a fight with other people. And so you're going to want to be thinking about your particular production and what types of claims that can arise from those productions, though you might not always think of a physical altercation in a, maybe nowadays you would in a reality television show, but it's something you want to make sure you know how that's actually going to be covered under your package of policies. So a typical claim that would be covered under media liability policy would be a copyright infringement claim. Copyright is obviously a very specialized area of the law. We have Dave Fink here, who practices as a copyright attorney and handles many, many copyright cases, which brings us to the issue of selecting defense counsel. I had mentioned before that oftentimes, your first call when you get a claim is going to be to like your copyright attorney, your trademark attorney, whoever it is that you get on the phone to say, we've got this issue. Though the insurance company is going to have their own attorneys that they might want to use, and that can be handled in a number of different ways. And Dave has a lot of experience in having their clients negotiate with their insurance company so that he can defend them either specifically or that his clients have a right to choose who they want to defend him. And I'll have Dave, if you could speak a little bit about your experience in that.
Sure. So I guess the way I look at it sometimes is there are 3 different times at which you can have a conversation with an insurance carrier about the selection of counsel. And the time that we usually think about when we start talking about selecting counsel is when a claim comes in and the claim is tendered to the carrier, and then the carrier has an idea of who they want to hire as an attorney, and the claim doesn't seem to suit the attorney that the carrier wants to hire. But that's actually sort of the 3rd phase in the timeline of when you can select your counsel. Every year or whatever the renewal period is for your various insurance policies, you have opportunities to negotiate with insurance carriers about the various terms of the renewal and what's going to be covered and how much you're going to pay. And one of the things that you can negotiate is how counsel will be selected if a claim arises that requires a defense. And so there are lots of options there. You can negotiate about who selects the counsel, and you don't have to name the counsel, or what happens if there's a disagreement about counsel, or what the rates will be. But one of the things you can do is you can literally put in your policy in writing that if a specific kind of claim comes up, or even if any claim comes up under a particular policy, you have a pre-approved attorney who is already selected that's approved by the carrier, and you can hire that attorney without having a discussion about who the counsel will be. And I have some clients who do that when they renew their insurance. They just specify that will be their attorneys. And in some cases, depending on the kind of policy, the carrier will also not only allow, but even encourage a certain amount of time to be spent in pre-claim analysis, even when the demand letter comes in as pre-approved time. So you can even have a policy that says, if any kind of claim arises or anything that arises that might be a claim, you are automatically approved to spend 10 hours of time or 20 hours of time with lawyer X analyzing the claim and responding to it before you have to even get approval from the carrier. And that can be a very handy thing when claims come in, because it allows you as an insured to find out whether something that comes in is really a claim, especially in the entertainment business. I have a lot of clients that get strange emails or calls from people who were, past clients or past people who were involved in productions, who feel that they were entitled to something, or they want to keep working with somebody, or they want something, and they're not sure whether that's a claim. And so it's convenient to be able to pick up the phone and call your attorney and know that the carrier has already approved the consultation, and it actually provides some comfort to the carrier too, because the carrier then realizes that you've recognized a problem and you've not decided to handle it internally without checking with a lawyer. A good example of that is where there's an intersection between labor and employment law and entertainment law. So let's say you work at a production company, you get a complaint for an employee about discrimination or sexual harassment or something. Sometimes people will be tempted internally to start investigating those claims, or to just tender them without thinking them through. Being able to pick up the phone and call your lawyer and ask right away what to do can sometimes help stave off claims that would otherwise be filed and save the carrier money. And so that's a good thing. And the other point is, especially if a case comes in that's complicated, and I'm sort of moving to phase 2, right? A claim comes in, you haven't pre-negotiated with your carrier about who's going to be hired, but you become aware that you might have a claim. And at that point, you kind of have two choices, right? One is you could pick up the phone and call your lawyer and discuss how to tender the claim and what to do initially about the claim, or you can write a tender letter to the carrier without talking to your lawyer first, in which case the carrier logically assumes that you're asking the carrier to kind of figure out who the lawyer is going to be and figure out how the case is going to be defended and analyze it for coverage. And so by doing the first thing and calling the lawyer that you think you might want to use first, that enables the lawyer to help explain to the carrier why the case requires a more complicated or a more sophisticated counsel than the carrier might otherwise appoint. And that of course, from the carrier's perspective, the big issue is rate pressure. The carrier wants to have the least expensive defense and the least expensive lawyer, so that you can possibly have, so that they can spend the least amount of money on the policy. But there can be a conflict between what's in the best interest of your company or your group and what's the best interest of the carrier. I'll give you an example of this. You can turn the slide, Sarah, if you like. A good example of this is when you have a claim like the one I mentioned, like an employment claim of some kind. Maybe the carrier is used to handling employment claims that are not usually entertainment claims. They're used to handling employment claims for somebody who works in a factory or works for a delivery service or something. And there's not really any chance that there's going to be any media attention to that claim. But in an entertainment company, for a media claim, there's always a chance that those claims can be reported and that they can cause harm to the reputation of the company, and that you have to manage a lot of other things, including the public perception of the claim and how the claim is handled in terms of your outward image and how it's going to be covered. And carriers oftentimes are not very good at dealing with those problems. And so you can have a conflict between the carrier's desire to play hardball on the value of a claim and our clients' desires to settle claims or keep people happy, or keep a production rolling, for example, in the middle of a television season. And so sometimes it's necessary to explain to carriers that those other interests impact the case as well, because negative publicity can impact the judge, they can impact the jury, they can impact the attitudes of the witnesses who are involved in the case, who are reading the publicity and start to read the publicity and change their opinions. And so these things have to be considered sometimes. But there are all kinds of complex issues, and generally speaking, carriers are not set up to handle that. Even carriers that issue media and entertainment policies can't possibly cover every single thing. That what you might have a media and entertainment policy that that has to do that, and then you get a claim in for a COPPA violation, a privacy violation or something, and the lawyer handling it doesn't know anything about privacy. Or you might have a labor and employment claim come in, and the person handling it only knows about copyright. So it's really important to make sure that you do that. And I've found that even in cases where the carrier insists that they're going to hire a particular lawyer, you can convince the carrier, if you're right, that they're better off using a lawyer that's proven and that knows the company that they're representing already and knows the ins and outs of how the company works. I've had cases where carriers have insisted that they're going to appoint a particular counsel that they're used to working for, that has extremely low rates. And then I've pointed out to them that the counsel that they've appointed has already missed things in our initial conversations or something as I hand off the matters. And invariably the carrier turns out to agree that it would be better if I handle it. The bigger issue is how you split the rates. And when it comes to the rates, that can be an issue. And what you usually really do there is you try to negotiate for the highest rate that you can, recognizing that it's not going to be as low as the rate that the carrier wants to pay to their ordinary counsel that doesn't specialize in this area, because the market rates are higher for this kind of work. And then, usually we have our clients pay the difference. And so usually we can come up with an arrangement where the client chips in a little bit, the carrier chips in the majority of the money. The carrier is happy because they get a more effective counsel out of the deal, and the carrier has to stretch a little to pay a little bit more, but they get better quality representation. And then the client is happy because they get to use their own lawyer and they're not paying that much for it. And so not nearly as much as they do when they hire the same lawyer for a claim that's not covered. So
David,
yeah.
Quick question. So how much success in terms of negotiating either selection or rates, how much success have you had making the argument to the carrier that, hey, this is in our mutual interest to appoint someone who's really an expert in this type of work, and even if the rates are higher, you're going to save money in the long run? And then after that question, we also have a listener question.
So I think the answer to that question is most of the time I'm successful in doing that. And one thing I want to point out is in most of the cases that I work on that are covered by insurance, the carrier, either if it's a media carrier, already knows who I am, or I've already worked with them before, and I have good working relationships with a lot of the carriers. And so it's a cooperative discussion. And sometimes it kind of like feels like putting on an old shoe, right? A claim comes in and the representative of the carrier calls and says hello, and we ask each other how our kids are. And then they say, look, I don't really want to pay that much for this. And I say, well, this is going to, there's going to be this defense we have to mount. And we have kind of a friendly, familiar conversation. Sometimes they say no. But the problem that they face there is if something goes wrong in the case and they had an opportunity to pick a better lawyer, and then the person makes some kind of catastrophic error, then they have a problem. So usually they're willing to work with you if you can articulate a good reason.
Thank you. All right. Well, thank you, James, for chiming in with a question here. James says that I have found in my 20 years of experience that standard policies of major US media liability underwriters is often poorly suited to the particular activities of insureds, such as individual authors and speakers. As a result, I have most often used manuscript policies with London underwriters. Do you have better experience tailoring US media coverage to authors/speakers?
Yeah, and I can jump in there. I mean, it's really, that's like a broker underwriting question. And I guess in my experience and how the market goes, insurers get in and out of the writing these types of policies, the kind of media, entertainment, what you're speaking about, publishers, policies. And so they're kind of always changing. They are always different. And I think the most important thing you can do, because there's so much market fluctuation, is have a really excellent broker that knows what's out there, what's available, can walk you through what you're actually getting. I mean, we've done for clients, because, you may not have more than one option sometimes in the market, but let's say ideally you would have more than one option. Basically, taking the two policies you're being offered and comparing those to see what's better coverage for you, what actually is more tailored to your business. And then, there's always the option to negotiate, though. Market factors usually determine how far you'll get with that.
And Sarah, in terms of comparing two different policies to one another, is that the type of question that someone should go to an insurance lawyer for, or is that a broker question?
Yeah, I mean, you can always start with your broker. They should be a great resource. But if you want to really dig down into, the difference between a duty to defend and a duty to reimburse policy, whether your defense costs are unlimited versus whether they're going to eat away at your total policy limit, I mean, that's really more of an insurance lawyer question who will actually review the policy and kind of let you know where the holes are there. But brokers are, you want to have a good relationship with your broker and hopefully with an insurance attorney.
Thank you.
No problem. I was actually going to chime in, Dave, what Dave was saying. For the situation where maybe you haven't negotiated ahead of time your right to select counsel, but you're, maybe being presented with an option for counsel that you're not really happy with, and you have your go-to, like kind of what are your rights in that situation? What are the pressure points you can hit with the insurance company to get the attorney that you want assigned to your claim? And I'll just go back in this selecting defense counsel slide, you'll see this cite to a California case that stands for the proposition that insurance companies have a duty to employ competent counsel, and they can be held liable for damages that result from their failure to do so, which is what Dave was touching on, that if they go ahead and let's say it's a copyright claim, but they employ an attorney who maybe's done one copyright case, but not that many, and you get hit with a really big judgment as a result of that, the insurance company has exposure. They know that, but it's worth bringing it up in a conversation with them to say, look, I'm really concerned here that this counsel is not going to be able to defend me adequately. And that also ties into the rates. So there are certain claims that you can hire almost anybody, any competent lawyer to handle, but that's not entertainment and litigation claims. And so when you have a claim like that, and I'm going to bring this up in the context of when you have a right to independent counsel, because this is often when the rates conversation happens with the insurer. And this is we're citing the California statute, but each state either has a statute or has their own kind of common law set up on when an insured has the right to select their own counsel. And it typically arises in a situation where there's a conflict between the insurance company and the insured on an issue that the insurance company could essentially control the outcome of in its representation of the insured. So this is usually, it's going to be set out in a reservation of rights letter, which is typically great news when you get a reservation of rights letter because it means they're defending you. But they may set out, we're going to defend you, but here are the three things that if they happen, we might come back and say this claim actually isn't covered. In that situation, you're going to have a right in California, and it's a little bit nuanced depending on the state you're in, but to be able to select your own counsel. But the caveat here is the insurance company is going to say, great, okay, but we're only going to pay at the rate that we pay our panel counsel, which is inevitably going to be much, much lower than probably the counsel that you want to use. And what happens in that situation? And Dave touched on it about the kind of negotiation that goes back and forth. And we have been very successful in getting those rates up. Some of the arguments that I guess, that appeal to the insurance company or that are kind of good buttons to push are that at least under 2860 in California, it needs to be panel rates for similar actions in the community where the claim arose or being defended. So Los Angeles is going to have higher rates than certain other communities. And it also has to be a similar action. So the fact that they pay, let's say, whatever, X rate to handle kind of dog bite claims and in some city, in the middle of the state, does not mean that is the rate they can then reimburse you for your own independent counsel. So that's part of the discussion you're going to have with them about why your attorney, they may not pay the full rate, though you can certainly argue for that, but why those rates are going to be higher than what they traditionally pay for the, the dog bite attorney.
Yeah, I was just going to say, insurance companies are practical too. So they will recognize once you start having that conversation that it's still more expensive to pay 2 law firms than it is to pay 1. So oftentimes what happens at that point is the insurance company says, okay, fine, we'll pay you to be the counsel. And then you start having a discussion about the rates and what the rates are in the community. And that allows you to, point out that the panel counsel that they were going to hire isn't really qualified to handle the case. And that's how you can negotiate with them about the rates.
Right. And Dave brought up a good point. I mean, a lot of the insurance companies that issue these types of policies, if they've been doing it for a while, they often know, the median entertainment bar is pretty small. They know these attorneys. There's going to be a lot of times there's a proven track record, which certainly makes it easier to get your counsel selected. This is just a slide showing a little bit of the law. These are where some of our clients, and the claims often arise, New York, New Jersey, Florida, and how they handle this issue. It's all a little bit different, but, it's essentially going to be a situation where you have a conflict and when you're going to have a right then to select your own counsel. Okay, so production policies is kind of the next. Actually, I'm going to pause for a second. I'm going to read you guys or say something very important. This is the code for CLE credit. So if everyone's listening, this will also get put in the chat box that you can, you can find the information there too. But here's the code. It's Entertainment 2021. And you will get about a week from now an email with these slides and a form for your CLE credit. And that's where you will input that code for CLE credit. So Entertainment 2021, this information should also be included in the chat. Probably be there in about 1 minute. Okay, so the next kind of a bunch of policies you want to talk about are what are commonly referred to as production policies. And this is the insurance policy that will be in place to cover the actual physical production of the content, the television show, the movie. So this is what is commonly referred to as first party coverage. So before, when we were talking about media liability policies, that's where someone's suing you. In the production insurance context, your company has suffered a loss. So, for example, a set, you're filming in another country. I had this happen in a case, filming in another country, a set collapses, that other country is then concerned about the safety issue of the workers on the set. They come in, they say, stop filming till we can figure out what's going on. All of a sudden you have a lot of extra expense being incurred because you have everybody there ready to film. You may have to change production sites, as people know, it can get very expensive very quickly. So production insurance policies have, they're all a little bit different, but they have kind of some standard pieces that are in most of them. One of them is cast insurance. And we'll talk about that right now. So cast insurance is gonna be where you have a above the line talent. So this is a story about Lindsay Lohan. And if they're not going to be available for a reason described in the policy, such as they get sick or injured or something happens to them, that you would have insurance coverage for the losses you're going to sustain in the production. This is this was in 2007, and one of the big issues when she was arrested was, is she going to still be insurable? Because ultimately, even what are referred to as small budget motion pictures are still going to typically be over, right, $10 million, 12, and those are considered small budgets. So you're going to need financing for that. Financing requires insurance. If you want to use somebody who's now become uninsurable, I mean, that's kind of the end of the story. So cast insurance is an important piece of that. And Dave, I know you've dealt with cast insurance issues and talent and how that all plays out, if you want to discuss kind of your experience with that.
Yeah, I mean, I think the issue is when you're dealing with cast insurance, if there's a claim, whenever you're dealing with a cast member, there are a number of cast members, right? And there's only one production company usually, or one or two, and there's a studio or distributor. And because there are so many cast members, they all have their own people that you have to deal with. So if you have an issue with the cast insurance, let's say you're representing Lindsay Lohan or something, there are a lot of people that you have to go through in order to gather information or get consents or get forms filled out or get coverage. And the actions of the individuals can also impact, as you say, the insurability of the entire production. So it can impact casting decisions, and it can also make it difficult sometimes to deal with issues that arise with cast members. But it's important to be able to know how the relationships work with the cast members, and to find out who the people are that are easiest to communicate with to get to the cast members. The production usually already knows that, but the carrier can sometimes run into trouble when they start making requests based on the notice provisions in the policies for information. Let's say somebody has a medical problem in the cast, and then they send a notice to a doctor or something asking for medical records. That can be a problem, because then the doctor basically will ignore the notice and no one can reach the talent. And so it can be, it's just important to remember that when you're dealing with cast members, you're dealing with managers and agents and entertainment lawyers and other people. So you have to build in a little extra time and a little extra handling for that is all.
All right. And so we can get to everything we wanted to cover today. I'll just kind of briefly talk about extra expense coverage, which is, so it's like in the set collapse example, the extra out-of-pocket expenses that were incurred as a result of that physical loss. And a lot of times there is a requirement that those extra expenses be tied to the physical loss. Of course, it's based on the language of the policy, so you always want to take a look. But I think the takeaway, though, is that so in that instance, there was also civil authority coverage, because the government of the country came in and stopped production. So in that instance, you have kind of two avenues of coverage, but typically for an insurance policy, it's like they want you to pick a lane, right? And the insurance company is always going to say, right, whatever the lower policy limit is, they want you to pick that lane. And civil authority coverage is typically going to be a more limited coverage. It's not the entire policy limit. It's usually a subset of that. So where you may have a $5 million production policy, you may only have, let's say, $500,000 for civil authority coverage. So that's also something to consider when a claim comes in and you're kind of figuring out how to handle it, to keep your avenues open for the highest amount of coverage. And the only other thing I'll say about that is, I handled a case where there was a bunch of different coverages available. It was a stunt man who was injured on a set. So there was, it was unquestionable whether he was an independent contractor, whether he was an employee. So we had potentially employee coverage. It revolved around a automobile, potentially auto coverage. The workers' compensation coverage was unlimited. Production was in one country. Stuntman's a citizen of another country. And the only point and takeaway there is that in that case, we never took a position of what exactly part of the policy covered the loss. Our position was it could be covered under any of these policies, and we kind of kept the doors open so that ultimately it was just covered, right? And that's part of it too, is making sure you're always aware of the different avenues of coverage and keeping your options open. And so I just brought up civil authority coverage. And let's get into the event cancellation issue, because that does also touch into civil authority. So Ethan, do you want to talk about the event cancellation policies?
Sure. And after event cancellation, we've got COVID on the docket. I know there was a question about that. Next slide, please, Sarah. All right, event cancellation policies. So these are specialty policies in that they are not super common like CGL policies. Some people are unaware they exist, but they can be extremely helpful depending on what type of business you run. So the great thing about these policies is that if you get over the coverage hump and the insurer agrees that whatever your loss is, whatever the cancellation reason is covered under the policy, then the loss formulas are really generous. So you can recover lost revenue from the event, expected income. And in the COVID context, we have worked with some clients who have basically been made whole for the cancellation of a major event. So you'll see here in the last bullet, I just want to give you guys a taste for the economics around this. This has certainly changed since COVID, but for example, one client purchased $4.5 million worth of coverage for an annual convention that cost them $16,000. And that was a great decision because they got all of that money back. So if you are any organization that relies for a significant portion of its income on high grossing discrete events, or even a series of events, then this is certainly something to look into. Next slide, please. All right, COVID and event cancellation. So something to know about these policies that came to light in the COVID era is that most of them contain a baseline exclusion for cancellations because of communicable disease. But at least prior to COVID, they would also often offer an extension to override that baseline exclusion. So this was, of course, the single biggest factor in our coverage assessment for the clients who brought us these policies was, do you have the communicable disease endorsement or not? But that was not the only complicating factor or potential obstacle to coverage. There's also a pretty strict definition of cancellation in these policies. So you'll notice it says here, the inability of the named insured to open or commence the event as originally intended, essentially. So what does it mean being unable to have the event, right? Insurers, especially when COVID first began, were facing a tough financial squeeze where there are tons of claims coming in. So we expected that they would take an aggressive negotiating posture whenever they could somewhat reasonably deny coverage. So in advising our clients, we were worried that, well, if there wasn't a shutdown order actually in place, technically, even if it's the right thing to do from a public health standpoint to cancel your convention, you could still have it if you wanted to. And these policies specifically don't cover if nobody likes your event and nobody comes to it because of that, they don't cover that. And if you just decide to cancel it because you don't want to have it, they also don't cover that. So where is the line between inability versus choice? And that led to a lot of our clients facing a squeeze because their constituents would be putting pressure on them to do the right thing and cancel the event. But behind the scenes, we were advising them that, hey, you're going to have a much stronger argument for coverage. This was especially at the beginning of March before the shutdown orders were actually in place, but we knew they were coming. We were saying, hey, if you wait a couple more weeks, the convention center might close. It'll definitely be, you'll be unable to host the event as originally intended. And we had success. They took some flack for it in a lot of cases, but we did have success making a stronger coverage argument because of that. And then once you get into loss calculation, we get into issues like, well, how much, you expected to make $5 million. How much of that can you make if you hold a virtual event instead of the physical event? And we found that adjusters were pretty reasonable once we got into loss calculation, and our clients would try to get as much money back as they could, but obviously it's not totally the same thing. And so they covered the difference. Next slide, please. All right, COVID. So as we all know, COVID has created a flood of lawsuits nationwide. And the most common issue that comes up is business interruption coverage, which usually derives from someone's property policy. So the most common trigger for property policies is physical loss or damage. So most of these business interruption cases have focused on what does that mean, physical loss or damage? And insurers will generally argue that that means physical structural damage. And insureds will say, hey, even if there wasn't a fire or a flood, I can't use my property. I physically have lost the ability to use my store in the way that I used to. So that's covered. So far, there have been more cases ruling in favor of insurers than insureds on this issue, but it is critical to note that even though so many people have these property policies out there, the terms can vary in slight ways, so be sure to look at yours. And it's also important to note that most of these are trial court rulings that are working their way through the appeal system, so I would say this is very much a live issue. All right, so outside of the property policy context, outside of event cancellation, what about other buckets of COVID-related insurance? So if someone brings a claim against your company alleging bodily injury or property damage, then assuming you have a CGL policy, the duty to indemnify and defend is triggered. So it's a pretty easy argument to say that, well, if someone came to my store, got COVID, and files a lawsuit alleging negligence because of that, what they are saying is, I got sick, I got bodily injured. And we haven't seen insurers, at least in my experience, be too aggressive about saying this doesn't constitute bodily injury or anything like that. And then, as Sarah talked about earlier, in production insurance, for those policies that have cast coverage, they often explicitly contemplate what happens if a cast member gets ill. So that's a relatively easy, neat argument to make to the insurer.
Sure, and I'll just add to that, I think, and the types of claims we've been talking about and the types of policies, media liability and production policies, have had better success in getting at least some coverage for their, business interruption, cast insurance, civil authority type coverages. In the property policies, after SARS happened in 2003, the property insurers were advised to add these virus exclusions to their policies. And so you have a lot of property casualty policies with those types of exclusions, whereas in the media liability and production insurance, those were not common. At least I've never had not seen one. And so they've been having at least better luck, even though it's still going to be an issue of kind of funneling it into maybe lower limits of civil authority type coverage.
All right, so as Sarah just alluded to, issues going forward. The insurance industry is always reassessing their risks. They are trying to make sure that they're not on the hook for anything large and catastrophic that they were not expecting. So real life events often create after the fact additions that become standard in policies like SARS that Sarah just mentioned. Another great example is 9/11, which led to the inclusion of terrorism exclusions in all types of policies. So expect COVID exclusions to be standard in new policies, probably across most policies. For example, we've already seen them in environmental policies and in event cancellation policies. I don't know, Sarah and Dave, have you guys seen them in others so far?
Yeah, I think any new policies, production policies are in a little bit of a different situation because they often have broader time ranges. They're not like a 1-year policy. Some of them are 5 years. So depending when your renewal is coming up, but that is also an issue being litigated right now. The attempt to add COVID exclusions or virus exclusions to production policies where that production may have been delayed because of COVID unexpectedly, and now you have a production policy that is up for renewal, and the insurance company wanting to add a COVID exclusion. So that is an issue being litigated right now.
I was going to ask both of you whether you had been involved in any of those conversations about renewals that are coming up now. and whether there's any flexibility being demonstrated by carriers at all.
In my experience, no, I think it's a pretty tough renewal market right now. Obviously, the bigger, and more business you have, the more flexibility and willingness to have these conversations and negotiations. But I think for all people trying to get insurance right now, premiums have gone up, and it is a tough renewal market.
And that includes non-COVID renewal issues as well.
Right.
Insurance is becoming more expensive generally.
Correct. That's correct. And less options. I mean, I think it's always cyclical. So like I was saying, sometimes right now, I think it's more likely than it was before that you're being offered one policy choice rather than a couple different to choose from. Okay, so there's, I guess, for CGL and I was also going to talk about, I don't know, I refer to it commonly as like a commercial package policy. We have a lot of different types of coverage bundled in one. The real takeaway for the discussion about these two types of policies, so CGL, which is the very common, every business pretty much has it. It covers property damage and bodily injury claims. As well as when you have it packaged together, which could also include auto, property coverage, workers' comp, employment practices liability. The takeaway is that these are policies you should also be looking at as well. I have had experiences where, your first line of defense may be the production specific policy, but maybe there's an exclusion. You could have a commercial package policy that provides coverage for a claim. So even though they may not be written for a specific production, they may just be written for your company. It is always worth taking a look at those policies as well when you're faced with a claim that you're trying to find coverage for. And one of the big issues that we often are asked a lot about is allocation and settlement. So allocation referring to, you will often have both claims that are covered under a policy and claims that are clearly not covered under a policy in one lawsuit. And how does that work out? And how does it work out when it comes time to actually settle? And so I think it's important when you're having these conversations with your insurance company or internally that you understand the different pressure points that everyone's kind of dealing with. So as we said in the beginning, an insurer's duty to defend is very broad. So all that it needs to have to be triggered is a claim in a lawsuit that could potentially result in covered damages. And so that's pretty broad. It's just the potential for coverage. Could it be out there? Now, when you trigger that duty to defend, the insurer's obligation is then to defend the entire lawsuit. For any Lakers fans out there, this is a picture of Jerry Buss, and he was involved in a very famous coverage lawsuit in California called Buss v. Superior Court, in which one of the things that the California Supreme Court held was that even though only one of the 27 claims were actually covered, the other 26 claims in the lawsuit were not covered, the insurer was still obligated to defend the entire lawsuit and provide immediate and complete defense. This case, I often cite also when an insurance companies may be dragging their feet in terms of reimbursing costs, which is can be a frequent problem. And I'll ask Dave in a second about that. So this is the proposition that the insurance company has to defend the entire lawsuit. Now, here's the other good news for the insured is that when the insured is faced with a settlement offer, the insurer has a duty to accept reasonable settlement demands within policy limits. So the insurer cannot be saying, and they are often put in this position where, let's say only one claim is potentially covered and maybe the coverage argument is fairly weak. And now all of a sudden they're being asked to, put all their policy limits on the table to settle a claim. And they're now in that position. Okay, so that's their pressure point, because if they don't accept what's a reasonable settlement offer, which is to the merits of the claim, is it likely that if you proceeded with this lawsuit, there could be a judgment that was more than what you're being offered, in which case the insurance company would be on the hook, even if it's above their policy limits. So that's their pressure point. Now, what you will often get cited in your reservation of rights letter or back to in these discussions is that the insurance company is going to have a right to seek reimbursement. This is the Blue Ridge case in California. And the idea here is that if it turns out that, some of the defense wasn't actually covered, or let's say you figure out down the road that whatever the claim, there really was not an duty to indemnify, they have the right to come back and seek reimbursement from you. Now, ultimately, how this resolves itself is everybody, a global resolution. So you want to settle with the plaintiff. You also want to settle with your insurance company. You figure out who's going to contribute how to the settlement, and you kind of want to all walk away if possible. But those are the pressure points that kind of everybody is thinking about when they're trying to figure out what is that settlement number that everybody can live with. Dave, I had brought up something and now I forget what I was going to ask you about. Let's see.
I think you are going to ask me about the, when it comes to allocation, what the conversations are like with, between the carrier and the client, and how you resolve those when the carrier can be hard-nosed about the value of the claim. And sometimes that does arise. You have a situation where the client our clients have an interest in resolving a claim for reasons which are unimportant to the carrier. So the carrier might be evaluating a claim and saying, this copyright claim should only be worth this much. And that's usually somebody who's, not litigating these claims, but sitting in an office somewhere, sort of pulling those numbers from cases that are maybe not so comparable, or more importantly, or more commonly, that we might have an interest in settling a case for reasons that just aren't covered. Maybe the case is generating a lot of negative publicity and we need to resolve it in order to allow the client's business to continue successfully. And maybe the case, maybe we're willing to maybe overpay a little bit in order to make sure that we're handling the case from all angles. And so sometimes there is a negotiation between the carrier and the client about what the client is willing to pay to chip in to make up for the difference between the settlement demand and what the carrier thinks the case is worth. Usually though, generally speaking, we're pretty successful in getting the carrier to pay the full amount once we go past the deductible. So it just depends on what status the case is in. And one of the effective tools that we have is explaining to the carrier. It often depends on what stage the case is in, right? So if you're in a litigation and you're in the beginning of the case and you have a lot of expenses going forward that the carrier is going to be forced to pay, you can sometimes point out to the carrier that even if the carrier disagrees with you about the value of the claim from a settlement perspective, the net cost of continuing to defend the claim, if the carrier is stubborn and we can't settle the claim, will be higher to the carrier than just paying a little bit more than the carrier thinks the claim is worth. And so that's a constant tug of war whenever we get into settlement discussions with the carrier. And it happens in all kinds of different cases: copyright cases, First Amendment cases, employment cases. It's just an across the board thing.
All right, everybody, we've reached our hour. So I just want to say thank you very much for joining us today. Here's our contact information if there are any questions that came up that you want to ask. And thank you very much.